Hello guys, and welcome to another episode of my lecture. And on today's episode, we'll be talking about the fourth requirement as to the admissibility of a confessional statement. The fourth requirement relating to the admissibility of a confessional statement. In my previous lectures, we've discussed the first, second, and third. In this one, we'll talk about the fourth. And without further ado, let's go straight to my notes. The fourth requirement stipulates that the prosecution must prove that the confessional statement was voluntarily taken, and it is only the judge that can determine if a confessional statement is voluntarily given or not, as we can see in the case of DUPOP versus PINLIN 1975. The burden of proving the voluntariness of the confession is on the prosecution and can only be discharged if the court, note, if the court is satisfied beyond reasonable doubt that the confession is voluntary, and the question whether a statement is voluntary is for the judge. Now, also, when we look at section 29, subsection 2b of the Evidence Act, it tells us that in consequences of anything said or done which was likely in the circumstances existing at the time to render unreliable any confession which might be made by him in such circumstance. This is where it's very important. The court shall not allow. The very important thing to note is that it says that the court shall not allow the confession to be given in evidence against him except insofar as the prosecution proves to the court beyond reasonable doubt that the confession, notwithstanding that it may be true, was not obtained in a manner contrary to the provisions of this section. So this tells us, more importantly, that when we are dealing with confessional statements, it is not what the prosecution says that matters. It is not what the defense says that matters. It is what the court says that matters. Also, there was something that was stated in section 29, subsection 3, which is very important to us. The fact that regardless of whether or not the confessional statement is true, that is not what the court wants to know. What the court wants to know is whether or not it is voluntary and reliable. The reliability as opposed to the voluntariness of that confessional statement is a key element in determining the admissibility of the confessional statement. What I just said, I'm going to explain better in my next lecture. But in this lecture, it is very important to note that it is what the court says that is important. So that when you are going on appeal, you don't appeal on what the evidence is and all that. What you appeal is what the judge has said. I told you that when you are conducting a trial within trial, which is a trial that is used to determine the admissibility of a confessional statement, I told you that the judge has to stand down that particular case that is currently going up and start up a new trial. That is why it's called trial within trial. Now, there has to be examination in chief, cross-examination of witnesses, both by the prosecution and the defense. And when they do that, they are still going to do their oral argument, final oral argument on that admissibility of the confessional statement as to whether the court should admit the confessional statement or not. Do you understand? After both parties have argued before the court, then the court will then go back into chambers, or if the court has a decision already made, will read out the decision, because there has to be a decision regarding the admissibility of the confessional statement. And that is what section 29 subsection 2b of the Evidence Act has come to tell us. The fact that the court has to give a decision in relation to the trial within trial, and it is upon that decision that we would know whether or not that confessional statement is admissible, and the court must give its reasons why he admits it or why he rejects it. Also, very importantly to note is the provision of section 29 subsection 3 of the Evidence Act, where it states that in any proceeding where the prosecution proceeds to give in evidence a confession made by a defendant, the court may of its own motion require the prosecution, as a condition of allowing it to do so, to prove that the confession was not obtained as mentioned in either subsection 2a or b of this section. Now, what this is telling us is that even the court, without the defendant objecting, the court may of his own motion, you are about to admit a confessional statement, because this provision is relying on section 36 of the Constitution that says that where a person is charged with a crime, that person is innocent until proven guilty, because they know how fertile that particular confessional statement can be. Even where the defense doesn't object, the court may of its own motion require the prosecution to prove that that confessional statement was not gotten under grounds that we can have under section 29 subsection 2a or b. Do you understand that? And that is that for requirement number 4. We then go to the fifth and final requirement, and like I said earlier, this fifth and final requirement is based on the very key elements that we should look at when we are arguing a trial within trial. During your final submission as a defense counsel in a trial within trial, what is that key element that you must argue? Also, as a prosecution, what is that thing that you must be able to point out to the court that the court would give judgment in your favor? That's what I'll be discussing in my next lecture. I will see you in my next lecture.